Hello everyone, welcome to my channel, Our Indian Laws. These are the list of very important judgments on Negotiable Instruments Act of Supreme Court and High Court which may be useful for Judicial Services exam. In case of Pradeep Kumar versus Postmaster General, the Supreme Court held that under Section 78 of Negotiable Instrument Act, if a payment is made to a person who is in possession of the instrument but he is not entitled to receive the amount due thereon in his name, is not a valid discharge. In case of Dasarath Bhai Trikambai Patel versus Hitesh Mahindra Bhai, the Supreme Court held that it is no offence under Section 138 of Negotiable Instruments Act if check is presented for full payment without endorsing part payment made by the borrower. That means when a part payment of the debt is made after the check was drawn but before the check is encashed, such payment must be endorsed on the check under Section 56 of the Negotiable Instrument Act. If the unendorsed check is dishonored on presentation, the offence under Section 138 of Negotiable Instrument Act would not be attracted. In the case of Oriental Bank of Commerce versus Pramod Kumar Tiwar, the Supreme Court observed that a drawer of a check is liable even if the details in the check have been filled up not by the drawer but by some other person. In this case, the Delhi High Court permitted the accused in a check bounce case to engage a handwriting expert to determine whether the details that were filled in the check were in his hand. In the case Pawan Kumar Goyal versus State of UP, an additional accused cannot be impleaded subsequent to the filing of the complaint once the limitation prescribed for taking cognizance of the offence under Section 142 of the Negotiable Instrument Act. In the case Krosaki Refractories Limited versus SMS Asia Private Limited, the Supreme Court held that entertaining a petition under Section 482 to squash the order taking cognizance by the magistrate would be unjustified when the issue of proper authorization and knowledge can only be an issue for trial. And Company versus Anil Ramrao Nayak, Justice S.M. Modak of Bombay High Court held in his judgment that no doubt check is negotiable instrument which is transferable and negotiable. Presumption under Section 138 of the Negotiable Instrument Act can be drawn only when the preconditions are satisfied. The complainant unilaterally has put in dates on the check without the authority of the accused and even by not informing him. So, it amounts to material alterations. If it is so, such negotiable instrument becomes void. In the case Mr. Ashwin Ashok Rao Karokar versus Lakshmikant Govind Joshi, the Bombay High Court has said that courts don't have a duty to grant interim compensation to the complainant in a check bounce case. If interim compensation is granted, the judge has to record reasons for determining the amount of interim compensation. The court said that the provisions of Section 143A of the Negotiable Instrument Act 1881 are directory rather than mandatory. In the case Indranil Mukherjee versus State of West Bengal, the Calcutta High Court held that an order of interim compensation awarded under Section 143A of the Negotiable Instrument Act cannot be recovered from the estate of a deceased accused who died before the conclusion of a trial. The court further opined that in the event of the death of an accused, compensation awarded under Section 138 of the Act can be recovered from the estate of the deceased accused. However, an interim compensation awarded under 143A of the Act cannot be recovered from the estate of the deceased accused. In this case, dear friends, please understand that compensation awarded under Section 143A of the Act cannot be recovered from the estate of the deceased accused. but we can recover the compensation awarded under Section 138 of the Act from the estate of the deceased accused. In the case Miss Todi Investors versus Ashish Datta, the Calcutta High Court has held that the appeal against the acquittal of the accused in a check bounce case can be filed only before the High Court under Section 378 subsection 4 of Criminal Procedure Code and not before the Sessions Court. The court has held that since a case under Section 138 of the Negotiable Instrument Act is initiated by way of moving a complaint, the person who moves a complaint can't be held to be a victim as per Section 2WA of Criminal Procedure Code, and hence no right accrues to him to file an appeal before the Sessions Court as per proviso to Section 372 of Criminal Procedure Code. In the case Ramesh Kumar versus State Bank of India, the Himachal High Court held that if a drawer of a check fails to raise probable defense or deny issuance of check and signature thereupon, strengthens presumption under Section 139 of Negotiable Instruments Act. In the case Muhammad Abdul Qadir versus Munishwari, the Madras High Court recently allowed an accused under Section 138 of the Negotiable Instrument Act to examine complainant's side of witnesses while setting aside the order of a lower court. In the case Nagraj versus Ishwar, the Karnataka High Court has said that an acquittal order cannot be passed by the trial court under Section 138 of the Negotiable Instrument Act for non-appearance of the complainant while recording the plea of the accused. That means complainant's presence not necessary while recording the plea of the accused. In the case Sumit Deb versus Joy Deb, the Tripura High Court made it clear that under Section 138 of the Negotiable Instrument Act, if the original complaint is filed after the expiry of the statutory period, then in such cases, before condoning the delay, according to the proviso to Section 142 subsection B of the Negotiable Instrument Act, the accused shall be given a notice along with the copy of the application for condonation of delay. In the case R. Bharat Baran versus R. Nallatambi, the Madras High Court has held that it is not mandatory under the Negotiable Instrument Act to obtain both signature and thumb impression for a pronote to be valid. In the case A. Seating versus Nandini Modulars, the Karnataka High Court has said that if a party opposing the proceedings instituted under Section 138 of the Negotiable Instrument Act fails to raise the ground of delay in filing the complaint before the court of first instance, the court in appeal is empowered to remand the matter back for fresh consideration on the issue of condonation of delay under Section 142 subsection B of the Act. So, dear friends, if you consider these cases are useful to you, then please like, share and subscribe to my channel, Our Indian Laws. Thank you.